final and executory, and also game-changing. The Supreme Court has ruled on last year's Sara Duterte impeachment case with finality, but the response from key lawmakers and from some constitutional lawyers has been critical. Is impeachment, to quote Senate President Tito Soto, now an impossible dream? Hi, I'm John Nery, and you are in the Public Square. To help us navigate through the new terrain that the Supreme Court ruling has opened up are two lawyers and impeachment scholars whose counsel we also sought last year. Joining us via Zoom is senior lawyer Maria Lulu Reyes, a professor of law at the St. Louis University School of Law in Baguio City, a former bar examiner, and the co-author of the Philippine chapter in a book of global practices in impeachment. Joining us here in the studio is attorney Paolo Tamase, assistant professor and associate dean at the UP College of Law, and the author of an influential paper on emerging issues in impeachment. Welcome back, Attorney Lulu and Attorney Paolo, and thank you yet again for joining us in the Public Square.
Thank you for having us.
Thank you, John, for inviting me back.
Let me start by asking you both your general reaction, first of all, to the second ruling, the January 29, 2026 ruling. Let's start with Attorney Lulu.
When the July 2025 decision came out, my first initial reaction was, this is a trauma response by the ponente, maybe because he experienced being at the throes of impeachment himself in the sunset years of the Duterte administration. I thought it was too detailed, too emphatic on judicialization of the impeachment process, and that there was unnecessary hook on due process rights of impeachable officials. And that added length but not enlightenment to the process itself. Reading the resolution on the motion for reconsideration, again, my knee-jerk reaction was that this is an anti-anxiety pill that the Supreme Court has placed or put on ready to be swallowed when impeachable officials are under that threat. Because my general take on this is that the Supreme Court, in both its decisions, have made the impeachment process, especially the citizen-initiated ones, really difficult to navigate through the halls of Congress, both in the House of Representatives and in the Senate.
Thank you. Attorney Paolo?
I guess on my part, it was really surprised, not at the fact that the result was the same, but that the reasoning changed significantly. I don't want to speculate on how the court comes up with its decisions or how it relates to the public, but there really was such a large clamor on how problematic the July 2025 decision was, especially in academic circles and in civil society. And clearly, the resolution responded to that by walking back a lot of the more supervisory language that it used in the July decision. But the result was the same. And that was the source of another surprise for me, which is, two new issues that come up in this decision that really weren't litigated by the parties, which seemed material in the resolution of the case. So ultimately, a lot of surprise there. I guess what I wasn't surprised with is how the court is now, as it was in July, a key player in impeachment that really is different from both the constitutional design as well as the textual intent of the Constitution. But that's really the regime we're working with now.
I still want to stay at the level of reactions. Is it possible to speak of regional or let's even say school-based reactions from lawyers? Is there like a consensus? I mean, how would you read? When the July decision came out, I think maybe partly because it seemed to be open for a reversal. There were some statements issued and so on. I don't see that. I mean, there have been statements from specific lawyers, but do you see any like collective responses on the horizon?
Well, I guess, on our part, I'm not sure if Attorney Lulu would agree, but the schools play a very important role in the shaping of certain biases towards public institutions, at least in the legal field. It's very hard to read across a large profession whether there's been a consensus around the decision. But at least from our end, when the decision came out, it was the day after I assigned, key reading I assigned to all my political law students, which is Jeremy Waldron's The Core Case Against Judicial Review. Basically a paper which questions why we have relied on the court so much for the definition of rights and to solve all of our other social problems. And when I assigned it to them, I got a lot of pushback, like, why assign it to Congress, why assign it to the executive department. And the day after the impeachment, everyone was basically, maybe some of Waldron's views make sense. So, but I think that's because at least from the school where I teach, there's a lot more critical instruction on the court. It's not just whether they get the decisions correct. It's also about the roles court in society. So it made for a very interesting discussion, even as, impeachment is completely unrecognizable now than it was just 2 years ago.
Attorney Lulu, if I'm not mistaken, you're in charge of your law school's Master of Laws program. Any collective feedback you might have heard from your students?
Okay, formerly I was the coordinator for the Master of Laws program of St. Louis University, but I've retired. But I still teach, so that when the July 2025 decision came out, I think among consumers of Supreme Court decisions, mainly law students and lawyers, most of them were surprised at how the Supreme Court came out with the rationale to justify the outcome, especially that at the time there was a popular movement against corruption. It was so blatant in the public sphere that it was hard to reconcile the Supreme Court decision with the object of the impeachment complaint at that time. So law students and lawyers were wondering why the Supreme Court had to go through such length in order to declare unconstitutional the impeachment. But I also work in civil society, and to be truthful, impeachment does not matter to ordinary farmers in the field, to, for example, vendors in the market. They don't even understand the implications of an impeachment proceeding, but they are rabidly against corruption. So there's a disconnect between those of us who consume the law on a regular basis, who are enthralled with the language of the law as written and as decided by the Supreme Court, and those who are mostly affected, deeply affected by corruption in government. That would be ordinary Filipinos. So the resolution last week did not change that disconnect. So there's still a sense of wonder, negative, if I may say so, as to why the Supreme Court decided the way it did. But to ordinary persons, impeachment is not fully seen as a mechanism by which to correct corruption in high places.
I think it will only be visible when it reaches the trial stage.
Exactly. I think when the trial in the Senate is played or gets played on social media on a daily basis, hourly, and every minute, that's the time it becomes a reality to most of us.
But would you agree with Senate President Soto that it's become an impossible dream? In other words, it might not even reach the trial stage in the Senate? Attorney Paolo first, and then Attorney Lulu.
I share, I think, every law professor's sentiment that it's much harder to do it now. But I think impossibility is a self-fulfilling prophecy. There's still that a lot is still in the Senate's court or in the House's court where they can basically still define impeachment and stop themselves from falling into the trap of, as Attorney Lulu says, judicializing the process. The Supreme Court's resolution kind of walked back from a lot of the details that it gave, but although it's still, I think, bizarrely provided for certain rules that were not really at issue in the impeachment case. But the House and the Senate are free to change their rules accordingly. There are ways to comply with the new due process standards that the court lays out without making it like a judicial process. So it might not be an impossible dream, but there has to be some creativity and a political will on the part of these institutions.
It would be an improbable dream. Attorney Lulu?
To me, the test of a good Supreme Court decision is how it is practiced later on by all other lower courts and by other agencies affected by that decision. So I tried to imagine scenarios in applying, in practical terms, in real-world examples, the twin decisions of the Supreme Court. I think it is not impossible. I agree with Attorney Paolo, but it's really the difficulty is multiplied several times. Why? For example, one of the term initiated has now been elaborated so much by the Supreme Court that the original meaning found in the Francisco decision has been added to. For example, in both decisions, an impeachment complaint is now deemed initiated, not just from the time that there is action of the House on it, but when there is inaction, when the 10-day period elapses without any action being taken thereon. But that has connection to the redefinition by the Supreme Court of the meaning of session days. Robert's Rules of Orders, Parliamentary Procedures, this is basic. A session day is when it's called to order, it formally opens until it is adjourned. And that's why the meaning of session day is not necessarily a calendar day. So when the House in its comments said that 2 or 3 days may in fact be one session day, the Supreme Court has agreed with that take. So that every session day is every calendar day where the Supreme Court is in session. Why does the decision encourage political maneuverings with that redefinition of a session day? Example, if an impeachment complaint is initiated on session day 1 and it never adjourns until 5 days after or 10 days thereafter, as far as the impeachment complaint is concerned, no action was taken thereon, and it is deemed dismissed or terminated. Even if there was no adjournment of that session that took 10 calendar days. And that happens in Congress. For example, if there's an important bill that is being deliberated, the General Appropriations Bill towards the end of December, for example, when everyone is rushing to complete the House version, there's only one item on the order of business. So they may take several calendar days, and that would be considered one session day until all the amendments have been adopted. But in an impeachment complaint, when 10 calendar days that Congress is in session elapses and no action, because it's not included in the order of business, etc., no action is taken thereon, the impeachment complaint is deemed terminated. And the 1-year bar already kicks in. So that effectively kills the citizen-initiated impeachment complaint. To me, that is too onerous for citizen complainants because they are left to the mercy of the House, which is not necessarily driven by bad faith in sitting on it, but because there are some other important matters that might need the time and attention and focus of the House at that moment. So in practice, there are many ways to mix the calendar days with session days. For example, an impeachment complaint is referred to the House on any given day, but near the time when it adjourns. There is nothing that would prevent a filibuster by any House member from running the calendar days into the full 10-day session or 3-day session or 60 days, etc., in order to kill the impeachment proceeding. As we all know, filibusters have taken so many days. But a filibuster, for example, will stop the clock. So the session is not deemed adjourned until the filibuster ends. But a filibuster who will stand there, or a group of filibusters in the House that would stand there for 10 session days, 10 calendar days, can effectively kill that impeachment proceeding and kick in the one-year rule. That's a sad scenario that I don't think the Supreme Court might have contemplated.
But in fact, this is part of the resolution of the new ruling. It was not part of the old one. Tama ba, Attorney Paolo? I want to understand the decision as it stands now, but I also want to compare the differences from the original. Can we start there?
On the session day issue, in the first decision, in the July 2025 decision, the court quite clearly said that session days are as Attorney Lulu defined them. Right? They start at the call to order and end at adjournment. And therefore, the first 3 complaints were properly referred within 10 session days, as the Constitution requires, or included in the order of business of the House within the required period. That changed in the January 2026 decision. So that's one of the 2 key changes I mentioned earlier. Now, because the court redefined session days, then it means that the complaints were in fact unacted upon by the time that the 10 session days had lapsed, as required in the Constitution, which meant, and the court further construed this, which meant that they were effectively dismissed, starting the one-year bar rule. We can spend 2 hours talking about why that is wrong. Attorney Lulu already mentioned Robert's rules. My main objection to it is really it breaks the tradition of the court deferring to Congress on how to interpret its own congressional rules. But the real problem I had with the change in the rule was the fact that it changed at all without notice to the parties. So
that wasn't raised by the motions for reconsideration?
No, because no one...
Because it was a one point.
Yeah, it was the only point that the government won, right? So they wouldn't really contest it in the motion for reconsideration. And I think even reading the comment, none of them raised a similar issue. So the fact that it changed without and despite the repeated calls for oral argument on this was, I think, problematic. Because it breaks so many of the rules that we have on appellate litigation, as well as the court's tradition of avoiding constitutional issues that are not raised before it.
What about the other key difference that you noted?
The other material difference that I think resulted in the court upholding the annulment while changing its reasoning is the fact that it now recognizes that the House can, while the House has the power to establish its own rules of impeachment, it is bound to also follow those own rules even against constitutional rules. So let me clarify that for a bit. Remember, in the July 2025 decision, the court said that upon the 1/3 vote in the second mode, it doesn't go straight to the Senate. It has to first confirm, or there has to be some compliance with all of these due process details that it lays out. In the January 2026 decision, the court walks back a bit and says that 1/3 in the second mode means forthwith proceed, and therefore it will go straight to trial, except if the House has rules that will prevent it from going straight to trial. And the court looks into the rules of impeachment of the House and finds a vague, textual vagueness, which it interprets to mean that the House itself requires the referral of the impeachment, even under the second mode, to the Committee on Justice. So again, we can debate about how the House's rules were vaguely construed. I tend to agree that the part was poorly written, but 2 quick points. The first is, this is not a new practice of the House. The House has observed this rule as late as the Corona impeachment because it used the same rules that the 19th Congress used. So nothing changed in the text of the rule, and yet the House consistently interpreted this as not preventing 1/3 of the second mode, rather, from proceeding right away to the Senate. The second quick objection there is that if the Constitution already says forthwith proceed, then it seems incongruous that the Supreme Court would sanction the House to violate that textual requirement in the Constitution to forthwith proceed. Because it now basically sanctions the House adding new steps to this express lane type of impeachment. So, but maybe just a quick third problem with it is, again, this was also not raised in the motions for reconsideration. So again, you have that surprise issue that ends up being pivotal to the resolution of the court.
Attorney Lulu, the ruling on inaction, is it correct to say that that was there in the original decision, except that now it's in the original decision it said the session days requirement was met, but now that it's saying it wasn't met because actually the 10 days expired earlier. Did I get that right?
For both the original as well as the resolution on the motion for reconsideration, the crucial question was whether or not there was proper observance of the constitutional mandate that there must be action within 10 days. So that was the center of the deliberations, and this is what we have now in both decisions. So in the original, the 10-day the 10 session day period was interpreted by the Supreme Court the way that the House of Representatives has always practiced it. However, by forwarding the fourth impeachment complaint, which was supported by 1/3 vote of the members of the House of Representatives, the Supreme Court in the original decision said that the fourth was already rendered invalidated because it's the one that was forwarded to the Senate when there was already the first impeachment complaint filed in December 2 that was acted upon. So that was not acted upon, sorry. So that by February 5, when the fourth impeachment complaint was forwarded to the Senate, the articles of impeachment, there was wrongdoing on the part of the House when it failed to act on the first and second and third because they were deemed archived or terminated. And according to the original decision, the fourth impeachment complaint had already been barred by the House by the first impeachment complaint. That's why the date of February 5, 2025 was very prominent in the original decision. In redefining the meaning of session days in the resolution, the Supreme Court stuck with its original decision that the fourth impeachment complaint forwarded to the House was already barred by the first one. The only difference now is in when the lock-in period began. So that by implication in the resolution, the 10-day, 10-session-day period locked the fourth impeachment complaint as of January 20, because since session day is now calendar day when the House is in session, if we really count the actual number of days that the House was in session from December 2, the 10-day period would fall on January 20. So it was locked as of January 20, 2025. So the 1-year period would have reopened as of January 26, 2026. That's the only difference, I think, as to when the lock and unlocking period began and opened. But the outcome is still the same, meaning the basic rationale of the Supreme Court that the fourth impeachment complaint forwarded to the Senate was already barred because there was a first impeachment complaint.
What about sham complaints? The resolution noted that still lay within the power of the House of Representatives to dismiss sham complaints. But the dismissal has to be, it cannot just merely be an archiving or like, just ignoring. Otherwise, it would be treated like a sufficient inform and substance complaint. Attorney Paolo?
Yeah. So the resolution and the decision, both of them accounted for the idea of a sham complaint. And the court was uniform there in the sense that a sham complaint wouldn't really affect the proper initiation and the 1-year bar rule. My problem wasn't with I think the decision, at least, or our problem was not with the fact that it accounted for sham complaints.
Okay.
The problem is when it accounts for complaints that are just a little more than sham, right?
Okay.
I mean, there are impeachable grounds. Clearly, it's verified by a citizen, endorsed by a member of the House, but they're clearly weak and intended to start the 1-year bar period.
Okay.
But the court doesn't account for that. It only says that sham complaints are prohibited. Or sham complaints, rather, would not start the 1-year bar rule.
You both spoke earlier of the judicialization of the impeachment process. In the the July decision, the court, I think, identified 5 or 6 steps for the second mode of impeachment to proceed. But in the resolution of January, it removed, I think, the first 3. Can you both speak on that? Attorney Paolo first.
Yeah, it was I think there was a strong pushback from academia, at least, on that judicialized part of impeachment in the July 2025 decision. That decision contained so many rules for the House to observe, which would be both in practice and even under its current rules impracticable or impossible for the House. So they require, for example, that evidence be presented or shown to all members of the House, that they must have copies of the complaint, that there must be an opportunity to respond. Many of these things have been removed from the July 2026 decision. January 2026 resolution. In fact, the court removed one requirement in the July 2025 decision, which was that the House must have had some time to read the complaint, which sounded a lot, forgive me for saying it, infantilizing the House, as if the House can't read its own complaints and papers. So that a lot of that language has been removed. But there are still a few due process guidelines that are left. And I think relevant to the ongoing impeachment complaints against the President and the Vice President, they don't necessarily touch upon the first mode complaints. Right? So at least as a historical fact, a lot of the due process details have been reduced.
Attorney Lulu, not to make light of the decisions and the resolution, but based on what you said earlier, removing this what I called old new steps, no? The ones that were imposed in July but now removed in January. Is that a transition from trauma to just quote-unquote mere anxiety?
No, I think so, because every impeachment decision that the Supreme Court rules upon, I always think that they're ruling about themselves, because after all, impeachment is the only way to remove incumbent Supreme Court justices, along with a host of other public officers. So I was thinking it's from trauma to anti-anxiety. Yes, the resolution of January 2026 somewhat mitigates the anxiety of impeachable officials, because now they are given every step of the process an opportunity to defend themselves because of the due process requirement that the Supreme Court has now embedded in the impeachment process. And mind you, the due process here is for the impeachable official. I still believe that in the first as well as in the second decision, it's the first mode that the Supreme Court has really reimagined and perhaps reformulated to the extent that it might not have been intended by the framers of the Constitution. By putting a lot of due process steps or safeguards in the first process, yung citizen-initiated impeachment, I think the Supreme Court has effectively made the process difficult for citizens to do so, and therefore tempers a lot of, to my mind, it's not just a tempering, but a restricting of citizens' rights to initiate or to file impeachment complaints. The second mode, when there is already one-third affirmation and verification by the members of the House of Representatives, that is more consistent with the spirit of the impeachment proceeding as envisioned in the 1987 Constitution. What I'm sad about is the citizen-initiated one. There's too much due process safeguard in favor of the impeachable official that the Supreme Court has imposed, practically deterring the progress of the impeachment complaint. I have always believed that the Francisco and then the Gutierrez decisions on when an impeachment complaint is deemed initiated, I've always disagreed with that. To me, an impeachment complaint is deemed initiated from the time that the articles of impeachment are filed or submitted to the Senate, because that is when true jeopardy can attach to the impeachable official. But nevertheless, because if we equate this to a criminal proceeding, the impeachment process in the House, while a constitutionally imposed process and now interpreted by the Supreme Court, there is no jeopardy yet for the impeachable official, because the threat of punishment is not real at that point. It's when the articles of impeachment are submitted to the Senate that the jeopardy becomes genuine, and therefore that's when due process rights should be accorded to the impeachable official. But with the Supreme Court decision on this, the due process safeguards have curtailed citizen-initiated complaints to a degree that made the process difficult and the outcome nearly unpredictable. That's my take here. There's another, if I may say so, there's one aspect of the decision of the Supreme Court in both the first as well as in the reso that I personally am concerned about. And this is the part of the decision which says that in case the impeachment is for the president and the vice president, the evidence must be tantamount or equivalent to support a claim that crimes of treason, bribery, graft, and corruption have been committed. However, for other impeachable officials, and if to avoid diba? I will quote it directly. I took down the notes. For other impeachable officials, the evidence must be sufficiently grave that they undermine and outweigh the respect for their constitutional duty and independence. So the language here is different because for the president and the vice president, the Supreme Court, to my mind, made a distinction. For president and vice president must be sufficiently grave, amounting to offenses described in Article 11 of the 1987 Constitution. That to me is alarming because now the Supreme Court has set two distinctions as to the degree of evidence applicable to impeachable officials. For the president and the vice president who are impeached, it must be, by implication, proof of guilt beyond reasonable doubt.
Yeah.
Because evidence amounting to crime is proof of guilt beyond reasonable doubt. But for the other impeachable officials, it's a lesser degree of evidence that the Supreme Court has prescribed. Where in the 1987 Constitution do we find that distinction as to evidence?
Is that part of the
That
decision?
really makes me disappointed.
Is that part of the decision or is it obiter?
It is in the decision, in both the original as well as in the resolution, reiterated in the resolution.
Well,
That already dictates to the House or to the Senate even as to what kind of evidence they should consider in convicting, not just impeaching, but in convicting an impeachable official. That is the part that many have overlooked, but one that I immediately focused on, because impeachment, for purposes of conviction, there's really no rule as to what degree of evidence. But the Supreme Court, in requiring that for the vice president and the president, they must amount to crimes committed such as bribery, graft and corruption, etc. There is no crime as culpable violation of the Constitution.
Yeah. If I can add,
Yeah, of course. Yeah.
just add quickly
That's my other take here. That's my new take.
Thank you. Attorney Paolo?
Yeah, that's a very good point about the problem, the overall problem with the tone of the decision. And it really sets so many rules that really were not an issue in the first place. So, in the first place, no one was asking about what standard of evidence would be sufficient to even push to trial or eventually to convict. But the court goes all the way to say that this is the evidence that's required. If you go back to the debates in public in February 2025, right, we had that forum in UP, and the consensus among the impeachment veterans was basically, this is a question that is addressed to the moral conscience of a senator. They are not capable, not every senator is capable of doing the legal weighing of these things. And so regardless of that, you have the court weighing in on an issue that was not actually raised. You also have the court weighing in on an issue on what would constitute an impeachable offense for officers who are not subject to that current impeachment trial. They include members of the court itself, constitutional commissions, and therefore you have to ask, what is the court doing in setting all of these rules before they are litigated? It seems like they're ending the debate on what it could constitute before it even gets to that point. So I kind of see why this has been, and it's not only Attorney Lulu that has said it, that it's a trauma response of the court to what actually, to past attempts to impeach its members.
Well, that is really concerning. I mean, so this would be the purest example of judicialization. I mean, so even offering or now imposing new standards of evidence to convict an impeachable official. So now this refers to the work of the Senate, not the House anymore.
And John, if I may close it, I think the ultimate danger there is that in case the Senate convicts, that is now a justiciable question that can be brought to the Supreme Court. Whether or not there was sufficiently grave offense amounting to crimes as defined by the or mentioned by the Supreme Court here, it now makes it a justiciable question. So it will never attain finality. That any conviction made by the Senate here in any impeachment proceeding is never final, because anyone, the impeachable official or the convicted official, can now question it on the basis of whether or not there was evidence sufficient to convict equivalent to the crime. So that is the ultimate danger here. So still, I can understand why the accusations that the Supreme Court has overstepped its boundaries. To me, those are well-founded fears. So it's a Supreme Court flexing its muscle over all other departments, especially in impeachment proceedings, which are really political exercises.
Now that the Supreme Court has, flexed its muscles, what can Congress do, Attorney Paolo?
I'd go back to the warning that Congress shouldn't fall into the trap of judicializing its own processes. I think despite all of the details that the Supreme Court can provide, there's room for Congress to argue a certain pushback. Right? And that's how high politics works. It's how our branches of government interact. While our system does acknowledge that the Supreme Court is the final word in constitutional interpretation, it is not beyond the checking of the other branches of government, and therefore the House or the Senate might well insist that this would be their processes. So I think it's important for the Senate and the House to look back at what happened in 2025, which is when the decision came out and it was widely criticized by so many people. Many actually found the House to have acted in a very mature manner, right? The way that they were conducting their press conferences, they seemed to be out to get to accountability. That should be the model of the House moving forward, especially as it deals with two even more highly politicized impeachment complaints. It can take it as an opportunity to support or to recover the institution from the latter half of 2025, where it was the center of the flood control issue. It is also going to be the challenge for the Senate. The Senate will be seen as, I don't want to use the word, but I can't find any better word, complicit in the dismissal of the complaint in 2025 against Vice President Duterte. It has the opportunity to recover its institutional state role as a high check on the highest officials in government through impeachment. So maybe they shouldn't fall into that trap of judicialization.
Attorney Lulu, as far how does the January 2026 resolution affect the ongoing impeachment campaigns now? So there have been a few complaints filed against President Marcos Jr. I think at least 2 have been filed against Vice President Duterte. How is it? Do we see the House responding in a different way now because of the Supreme Court decision?
I was watching and observing the proceedings of the Justice Committee on the impeachment complaints filed against President Bongbong Marcos, and admirably, the entire Justice Committee have tried their best to apply to the letter the Supreme Court decision in the Duterte versus HOR case. So they immediately calendared it, included it in the order of business, and then it was immediately referred. So to me, there is nothing assailable in the actions of the House so far with respect to the impeachment complaints against the president. But there is yet no action on the recently filed new impeachment complaints against the vice president, and I have no doubt that the House will behave similarly, meaning as much as they can, they will try to adhere to the letter of their own rules as well as the decision of the Supreme Court. And I think that really, di ba, it's to forestall any future question against the impeachment proceedings that might be raised again to the Supreme Court.
Attorney Paolo, I think the other week, the House Secretary General, after receiving the first and apparently weaker complaint against President Marcos Jr., was traveling, and so her office did not receive the second and the third complaints against the president. What would the Supreme Court have said about it? I mean, the Supreme Court did say no discretion on the part of the House Secretary General to receive or not to receive?
So I think honestly, I think the Secretary General's office should have received it, but this highlights, and now I only think about it, this highlights the danger of trying to impose so many legalistic rules on and really a pilosopo the branch, right? And you can't fault the House for being that. It's a political branch. It's not a legal branch of government. So I think the excuse that the House was giving, and I don't recall where I heard it, is that the rules say it's received by the Secretary General, not by the office of the Secretary General. So you now have all of that, and you know how it's not fun to talk to lawyers because pinipiloso po namin lahat. You're basically going to see that dynamic. And I think that might be one of the hidden effects of the decision and the resolution on the present impeachment cases. Before, when you had impeachment complaints in the House, there would always be some lawyer, some defense counsel who would try to go up to the Supreme Court. That's normal. You can't stop them from filing cases. But there was never an expectation that the court would actually act on those cases. Because the court tended to defer to Congress as much as possible. I'm not sure if that's going to be the case now. You might have some expectation and therefore reaction that because the court not only intervened in the Duterte case, but intervened so heavy-handedly in the Duterte case, that it's a possible forum to raise all of the complaints about the proceedings in the House and the Senate, despite not touching the core question of whether was evidence enough in the House's eyes and should trial proceed to the Senate. So those were the simple questions in impeachment before, but now you have all of these questions about was it really 10 session days before it was acted upon? Was it jointly referred to the Committee on Justice? Is there a House rule that requires further steps if it's a second mode? Did you observe due process standards? All of those questions are going to be addressed to the court. And now you can expect that impeachment, which used to be a quick process, because you want it to be a quick process because you don't want the political instability to fester, then it might be now a longer process that inevitably involves the court. You can also see that in the dynamic in 2025. When the Supreme Court started to act on the Duterte decision, it gave the Senate some excuse to say, right, that, we will not work on this first, or we will remand it first, subject to the Supreme Court. That uncertainty in whether the court will act, buttressed by the fact that it did intervene in 2025, might give an excuse to the Senate, or I think more to the Senate than the House, to not act upon the complaint, pending some question with the Supreme Court.
Maybe last couple of questions. Attorney Lulu, this might be an unfair question, but why didn't the Supreme Court allow oral arguments on such an important issue?
Exactly my question too. A PowerPoint presentation might have clarified a lot of things about how the House of Representatives conducts its own business. And I kept wondering why the Supreme Court did not even bother with oral arguments. But my speculation is that since the impeachment complaint has been forwarded to the Senate at that point, there was urgency on the part of the Supreme Court to decide the matter, and that urgency would not be served by conducting oral arguments. That's just my take. I remember it was February 5 when the fourth impeachment complaint To my mind, it was a consolidated one, was forwarded to the Senate, but that was also the last day of their current session before it went on recess. And it resumed session only after the elections. So the Supreme Court had, I think, less than 3 months within which to resolve, because it wanted to preempt any trial that the Senate was poised to conduct when it resumed session. That's my speculation. That's why no oral arguments. But sabi ko nga, PowerPoint presentation lang yan. Di ba ako napanood nila how the House operates, what is a calendar day, what is the order of business, what are the attachments to the order of business. Then the Supreme Court might have gained more clarity about how the House of Representatives conducts its regular day-to-day operations.
Well,
and that might have impacted the decision.
If I can add
Sure,
two quick points to that. The first is how oral arguments serve an important function in clarifying factual or quasi-factual issues that get to the court. Normally, the court is not a trier of facts, but in reality, it deals with a lot of factual questions that may only appear for the first time before it. So oral arguments serve that important purpose, but they serve an even more important purpose in the public seeing how the court decides. So these proceedings are not televised, but they are live streamed, audio streamed.
Yeah.
People get to listen to the types of questions that the justices ask. And while there have been fair complaints about the quality of oral arguments over time, I think there's still something that provides a window for the public to see the court at work. That said, there is a larger trend with the Supreme Court holding less oral arguments in the last few years. So before, actually, if there's a highly political decision that's urgent, the court would actually call for oral argument. And it's oral argument in 2 days or in 3 days. The Paolo Manzarez citizenship case, FPJ citizenship case, the Francisco case, I think, was also orally argued. You see all of those as a mechanism for the court to actually decide the case quickly, is to call it to oral argument. But that's not the direction that the court went with, inevitably.
Last question, Attorney Paolo. In the middle of last year, before we started talking about the flood control corruption scandal, people were talking about forthwith, and different definitions of what does it mean for the Senate, for the trial in the Senate to proceed forthwith. Are we any closer to clarity here? You did mention earlier the Supreme Court touched on that.
I think honestly, no. And I know that there's been some view that the court actually clarified a lot of the procedural rules. My sense is it just opened more questions. So, for example, on the forthwith, does it mean that you still have to give copies to everyone? The court says that you do need to do that for information, but what is sufficient information? Is it enough to just give them a courtesy notice that this complaint will be filed, or do you have to put it somewhere? So all of these new questions are arising, questions that lawyers would often ask, but not normal people who were the original audience of impeachment. But I guess that question also highlights one problem we have with the way that I think the case has ultimately proceeded, or the idea that we need clearer rules for impeachment. And that is, any rule in the Constitution, any text in the Constitution would always be subject to some interpretation. And no matter how many rules you put there, for example, if it is amended and you insert so many rules to defeat the court's resolution, you can expect the court will ultimately be able to resolve that, maybe towards its favor again. So it highlights that, these uncertainties in words should not really be material in our ability to hold our institutions of government to account. If forthwith was easy to understand for a normal person, even before 2025, then the Senate or the House should have acted according to that public pressure and not waited for a Supreme Court to define it.
Just to end everything, this makes me think that really the loser in this series of decisions is, as Attorney Lulu pointed out, the citizen complainant, who is not a lawyer, not necessarily a lawyer, just feels very strongly about an act or a malpractice of governance and now has to consider all of these things. Attorney Paolo Tamase, Attorney Lulu Reyes, this clarifies many of the aspects of the Supreme Court resolution at the same time as it deepens some of our reservations about that decision. Thank you very much.
Thank you, John.
And that's it for us. The challenge for engaged citizens in our country remains the same: to fully inhabit the democratic space and to defend the democratic project. Please download the Rappler Communities app and join the chat room of your choice. And if you haven't yet, subscribe to Rappler Plus. Thank you. This is John Nery. See you in the public square.